Hi, everyone. Let's go ahead and get started. Welcome to the 2021 ACEL Practitioners Forum. If you've been attending the research forum and professional development sessions throughout the day, I hope you found them useful and engaging. If you're just joining us now for the Practitioners Forum, welcome. So the Society created the Practitioners Forum 6 years ago as a counterpart to the Research Forum, by then a well-established international event. The goal was to strengthen the Society's connections with lawyers in practice and to foster collaboration among scholars and practitioners seeking solutions to some of the most complex issues confronting practicing lawyers and their corporate clients. Today's innovative session has the provocative title of Democratizing International Law Practice, Leveling the Playing Field. It considers the question from the vantage point of 2031 and features an impressive array of global legal practitioners discussing changes to the practice of international law fostered by technology, globalization, and new forms of private international law agreements that have grown in popularity. These changes will be evaluated in light of the goals of ensuring that the practice of international law addresses historic inequities, improves access for smaller clients, and centers human rights and environmental considerations. Pretty lofty goals. I can't wait for the conversation. Before I introduce our moderator to start the conversation, I really want to just take a minute to thank the Practitioner Forum co-chairs, Pedro Martinez Fraga, Danya Main Hewitt, and Jeremy Sharp, all of whom spent considerable time and effort in developing this very creative program this evening. I greatly appreciate their outstanding work, and I really do think you're in for a treat. With that, allow me to turn things over to our moderator, Professor Catherine Rogers, currently at Bocconi University in Milan. Catherine, the floor is yours.
Great, well, thank you so much for the introduction. And I'd like to thank all of those of you who are here with us virtually in Mark Zuckerberg's metaverse for the 2031 ACEL Annual Mid-Year Meeting and Practitioners Forum. Before I start, I have a few administrative announcements. First, for those of you who did not come in self-driving cars, I'm told you can get validation for your cars at the registration desk, for those of you who are here in person. Second, I'd like to confirm, as we always say at these events, that although we've invited our guests to discuss changes and offer their views and even to speculate, they are speaking in their own personal capacity and not on behalf of any of the organizations that they work for. So with that, let me tell you a little bit more about the panel. Here in 2031, we have convened some individuals who were prominent all the way back in 2021. They're really leaders in their fields, and they bring perspectives from all over the world. So starting, we have Shen Bao, who is an independent arbitrator with arbitration chambers in Singapore. She's also a vice president of the ICC Court of Arbitration. And I think, Shen, we've now known each other probably for, it has to be 30 years. It's been a long time. Good to see you here. Melinda Hodgson, who is a partner and the head of the New York International Arbitration Practice at Jenner and Block. She's also active in Blacks in the American Society of International Law and REAL, the Racial Equality for Arbitration Lawyers. Next, I'd like to introduce you to Emily Slater, who's the managing director of Burford Capital, and she's going to be telling us about their very interesting equity project. Finally, last but absolutely not least, Lady Lynn Contreras, who is the director of dispute prevention. What a nice title, dispute prevention and defense, with the Ministry of Industry, Commerce, and SMEs in the Dominican Republic. So, as all of you know, the Jeff Bezos, Elon Musk collaboration has built now a colony on Mars. And so international trade and commerce is no longer merely across borders on planet Earth, but has as well an intergalactic aspect to it. As a result of these developments, international arbitration, both commercial and investment, have also evolved significantly. Some of these changes, I think, can be traced back to at least to their acceleration during the pandemic of 2022, ended in 2022. And so now that that pandemic is really in our rearview mirror, we are inviting our panelists today to discuss in an open roundtable forum questions about what has changed since the pandemic, and in what ways has it, consistent with the title of the program, led to a greater democratization or a leveling of the playing field in international arbitration. Our format is going to be quite informal and very much sort of bouncing ball roundtable. So with that, let me get our panelists started with a first question about, have they seen since, and I'm going to go back a little bit before the pandemic, since let's say 2015 through now 2031, what kind of changes have you seen in the range of practitioners and in the opportunities that practitioners from different backgrounds have in international arbitration? And I'm going to just start with Melinda, excuse me, I don't know why I'm doing that tonight, Melinda, and tell us your perspectives, if you could start, and then you get to hand the baton off to whoever you pick right after.
Great, thank you, Catherine, and thank you to the organizers and through my fellow panelists. I think this will be a lot of fun. You're absolutely right that you need to go actually before pre-pandemic, looking back a lot longer range. I mean, we began, I think, I would say, tracing some of the sort of democratization issues, which of course are much broader than international arbitration, which is my sort of limited field. And I think in international law in general, and speaking about the society, the American Society of International Law, started to address some of these issues actually through the creation of Basel, which was, I think, formed right around the time, the period that you mentioned, to really address sort of a deficit in international law. And I think sort of the original creators of Basel, Judge Gabrielle Kirk MacDonald and Donald Donovan, sort of saw that whereas before there may have been some, I would say, brown folks in international arbitration, that had sort of almost disappeared, at least as far as it concerned the United States. And so what we've seen, though, is going from that time, is we've seen a greater awareness overall in international law and in international arbitration specifically. It really sort of all crystallized, I think, during the pandemic, where, and partly because of the tragedy of the George Floyd murder, where you had a reaction really that was worldwide, and that caused a lot of people to sort of sit back and say, how does this affect me? I may be sitting not in the United States. How does this affect me and my society and the rights of people, underprivileged people, indigenous people worldwide? And out of that also came an organization like REAL, which looked at not only focused on the United States, but looked at how we can give access to everyone. And again, this was really something that was beginning to happen. I think if you looked at the election, the issue over the election of the ICJ judges a couple of years before that, where there was really, I think, frankly, at the very least, a political statement that it was not going to be sort of one of the traditional Western white powers, but was going to be someone from a different part of the world. And so I think all of that started, but we've really seen over the years, and I think it's a great thing, that there's been much more awareness, and frankly, awareness by people who have the ability to affect change without asking for, let's say, a more powerful factor, or realizing that they're powerful in and of themselves. So we have countries all over the world, like the Dominican Republic, where the leaders basically said, we want these things to happen. And that's basically taking ownership of the issues and not depending on others to sort of solve the problem. It is something that all of us could be involved in. And I think that also makes it less of an us versus them kind of issue, and really helps to foster creativity. And I think that happened. And what we've seen over the course of the last 10 years, 8 years, 7 years is a greater diversity in the pool of arbitrators, a greater pool of lawyers who are practicing in international arbitration, but also in other aspects of international law. And I think that's been really fantastic that it has, there's still work to do, obviously, but I think we have seen that happen. And so with that, I'll go to another area of the world and maybe ask Shan to talk about her views.
Great, thanks so much, Melinda, and thanks, Catherine, for bringing us together and the co-chairs of this forum. The way I see it, sitting here in 2031, is just a reflection back on the last 20, 30 years. I see that education in international arbitration has been the key founder in what has driven change as to where we are today. And I would say that I would start with the Queen Mary School of International Arbitration. I remember 30 years ago, 40 years ago, I participated in the first international arbitration LLM program in Asia. And so I began my career only doing international arbitration. And so now we have 70-year-olds who have only seen international arbitration, and they've started from when they were kids, and they've lived in different countries, and they've picked up different languages. They have built an entire career around international arbitration. So I see that we have a more diverse pool than we could possibly ever imagine.
I have a happy fact for you on that, because I was just speaking yesterday to Stefan Kroll, who told me that this year there are 12 African teams registered for the Vismut, which, considering that just, I would say maybe 5 or 6, well, no, I guess 16 years ago, there were no African teams. So that's a huge benefit. And we were speculating whether they would be able to come when there's no, if it's in person or if it's only when it's online. But you're right. I think education is one of the great democratizers. It really is what creates opportunity. And we're seeing, I think, much more diverse LLM programs. I mean, it used to be that LLM programs were the elite European students, and now we are seeing them just all over the world. So that's great. And it brings me to Emily. I don't know if you could talk, because I know you're really focused in a very, I think, original and specific way to boost women in particular, as I understand, in your project. Could you tell us a little bit about that?
Sure, I'd be happy to. And thank you, Catherine, and to my co-panelists and to ASIL for the opportunity to speak today. Burford Capital is the world's leading litigation finance provider, and we have a very large practice in providing litigation finance for international arbitration, all on the claimant side. About 3 years ago, we launched a program called the Equity Project, where we created a dedicated fund of $50 million to provide finance for cases being led by women first chair lawyers or women who were getting origination credit for a representation. And we really started that because I had been at Burford already for many years and had practiced for many years before that. And in the hundreds and hundreds of cases that I had seen over the years at Burford, we'd seen a tiny handful of cases that were actually led by women. And we really believed that it was, we needed to provide an incentive to really help women be able to promote themselves and take the leadership role that they have earned over the years. And we were successful in financing, using that first 50 million in committing capital to cases, several of which are international arbitration cases. And, following up on looking back again at the, great awareness, I think that, particular awareness that the George Floyd death brought to everyone around racial inequity as well, that we decided to relaunch Equity Project 2.0 with a $100 million fund, focusing not just on leading women, but also historically underrepresented minorities in the practice. And looking back today in 2031, I'm so pleased that we have used that full fund and launched several more. And continue to see a growth in the diversification of practice, not just in elite lawyers at major firms, which had really been Burford's focus for its first 10 years, but a broader array of lawyers around the world in jurisdictions all over the world, in Africa, Asia, and as well as Europe, South America, and the United States.
Great. Wow, what a fantastic program. And it is a really quite literally put your money where your mouth is, right? Which brings me to another sort of, living example, which is Lady Lynn. I would say, at least from my perspective, another one of the really big developments were states, in a sense, taking, I don't know if you would say this democratization, but democratization among states and state parties, right? Them taking back their representation in-house. And what I see tied back into Shan's point on education is these amazing young lawyers, probably younger than many of the people they were referring to, dramatically younger, who've done these LLMs and so have had formal training in international arbitration, leading, highly successful teams within states. And it seems to me you're the kind of physical embodiment of that example. How would you say states have changed their approach to international investment arbitration in the last 10, 15 years?
Yes, it has been a great difference since last 15, 20 years, and not only because of women leadership in different positions, leading institutions, leading ISDS reform, but also the point that you highlighted within our in-house teams within the government. You have feel the impact of capacity building, of awareness, not only on the defense team, the prevention and defense team, but also among our authorities, the implications, for example, of signing a BIT with the proper consideration, with the proper provisions, not only for providing protection and promotion of investment, but also safeguarding states' regulatory capacity. And this has been a result of the jurisprudence of the different awards, the different interpretations that have led us to question the system and to propose these different reforms. But I also think that there has been more awareness, and as Kian said, also education, the importance of dispute prevention. I remember when I started working on this field, talking about mediation or conciliation was a bad word because some authorities thought about it as a recognition of a liability without thinking how important it was to sit on the table, to meet face to face to my counterpart, to know from a personal perspective or a direct perspective, the claim, what's their position, and there was nothing to lose, only to have more time to properly know what was their case and what possibilities we have in order to prevent, if possible, and through the authorized channels and mechanism and authorities, a conciliation or a mediation before the commencing of a formal process. So yes, it has been an incredible involvement of this field, and from a sovereign perspective, we have, without any doubt, feel the impact of all these changes and reforms.
Great. No, that's a really interesting. Go ahead, Shimmer, you can jump in.
Sorry, I was just gonna just comment on Lady Lynn's points. And first of all, I have to say, I love your title of being in the Department of Dispute Prevention. I think that is hopefully commonplace amongst your peer states now. And I think
it was created, formally established as a direction in 2021, many years ago, an exclusive direction for the prevention and defense of our investment cases.
And that I think is fantastic. And I think that we're seeing that as a commonplace now. I think the great disruptor of the pandemic brought to us a more better recognition of ADR processes and systems. I think that was a moment where we saw that mediation could be helpful, certainly in commercial arbitrations as businesses were coming out of the pandemic. And certainly it's great to see that states have adopted this as well. But I think beyond mediation, I think there are other ADR systems that have been risen to the fore in the last 10 years, including dispute boards, expert determination, and the like. What I'm interested in seeing these days is decentralized justice. I mean, certainly technology has certainly played a role in the last 10 years, and or companies such as Claros or these blockchain kind of groups and companies are also facilitating in bringing us a broader range of dispute resolution processes.
Yeah. I think we're seeing, and there's all forms of democratization and access to justice, I guess is one other way of putting it. Sort of shorter term, I would say sort of having a menu, an a la carte menu in a way for different types of disputes. So we started to see 10 years ago, 15 years ago, sort of expedited procedures for different size types of claims. And I think we've seen that progress, as Sean has said, to sort of having a little bit more tailoring to different kinds of claims and being able to resolve claims that maybe never get to a full arbitral setting. I will say that I think it took time, the challenges of technology to get to that point of being able to provide that kind of service. And I think one of the issues that the pandemic raised was sort of differing access to technology, and not everybody had great Wi-Fi. We have different kinds of systems now, and we can bypass Wi-Fi, but those were some of the issues that I think further helped to develop sort of a greater access to justice.
I guess from the financing side, additional pathways for disputes, especially right-sizing the kind of dispute process. Doing a treaty dispute in ICSID in 2021 was often, a $10 or $12 million cost in terms of bringing a dispute. And there are many, many disputes that simply just couldn't be adjudicated because they were just simply not large enough in terms of what potential quantum could be to justify bringing a dispute. So having faster track dispute mechanisms, I think, has really helped democratize access to justice in a significant way, and really sort of brings the economic rationality to that. And I also, I think, I'd like to see, the development of potential public funding for bringing disputes on behalf of small parties, I think would be continue to evolve, going forward here from 2031 to see additional access to dispute mechanisms, private dispute mechanisms.
I have a fun fact on that one too, because this is an outdated statistic from 2021 or 2020, but when we talk about these smaller disputes and access to justice, we think, okay, well, they're outside of our realm, but the ICC, 40% of its cases are under $10 million. They don't make the GAR headlines, and they aren't the ones that, we talk about at conferences so much, but 40% of the ICC cases, and the ICC, of course, having the highest value caseload, means that at other institutions, it's actually a greater percentage of their overall caseload. So it's not this esoteric, unusual little small case. We're talking about a very big chunk of the market. which presumably also expanded with the pandemic, the breakdown in supply chains. Those are small, oftentimes small agreements. Going from kind of smaller cases to it reminds me of another trend I wanted to ask you all about. I think starting 20 years ago or so in 2011, we began seeing what I think could be characterized as a pretty steady stream of breakaway boutique firms. That's at least what I'm going to call them, meaning breakaways from large multinational usual suspects, so to speak. And then I would say the other big rise that we've seen, and Lady Lynn probably knows a lot about this as well, because I've seen a lot of it in Latin America, is I would say the rise of prominent regional, very experienced regional firms. And so I was wondering if you agree with, I see heads nodding, so I guess people agree, but what's your perspective on how that happened, why it happened, what's been the effect on democratization of international arbitration? Lilian, so I tagged you first. You're more than welcome to start. Again, because of Latin America. Yeah.
Thank you, Catherine. Indeed, we have seen a proliferation of small boutiques, law firms, and I think it has not only broadened the universe of different law firms specialized in international arbitration, and from a state's perspective, there is incredibly, there is many law firms that fits the requirements, depending of course on which region you are located, that fits your requirements in order to provide you with defense. But this has been a significant element. Very well prepared, very eminent professionals has emigrated for smaller boutique firms. And I think that it has also had an impact on the budget of the cases. I think when you request, for example, for a proposal, because of the different amounts that you can see from the different law firms that present, you can democratize like the budget you will be handling. So I think that also on the budget side, it has had an impact. And I think also on the diversity, not only on gender diversity, but also for us to be able to consider, for example, younger practitioners in order to be nominated or appointed as an arbitrator, in the way that these teams, that these high profile people has established new boutique firms, and they have developed their own career and their own profile. They have been more recognized, and I think that it has also influenced the gender diversity, and as I said, the possibility to be considered a younger practitioner, for example, that maybe before making that step will not be considered in the same way.
I think a little bit it's a result of what Sean was saying. I mean, you had, 15, 20, 25 years ago, really lawyers starting out their careers as arbitration practitioners. And so they, did what typically is done in many US firms, but in different fields than arbitration. And you start out in that practice and not necessarily having to transition into the practice. And so you're then, I would say, better prepared at an earlier age to branch out. And I think it also is a result of sort of needs of states in terms of having to manage public budgets and not having, this is something that's being worked on, but not having funding available for a lot of claims. And so it's a sort of a convergence of various factors.
Catherine, your point about observing Latin America's rise in massive regional arbitration practices, we in Asia saw about maybe 10, 15 years ago. I remember in 2010, many of the cases were dealt with by international firms that were flying in. And then around the pandemic or so, or before then even, you know, you saw Chinese local firms representing themselves, Korean local firms representing themselves. And so we started seeing that here in Asia, where there would be more confidence amongst regional firms to take on their own clients. And I think that that has only spawned in the last 10 years. And I think that will continue to trend in that direction and create more options, as Leyland said, for clients, but also create different types of cost structures, and language will no longer be the real issue, but rather cultural connection with their clients has been a welcome thing for clients and choice. And so the international boutiques, I think, will find themselves to be further specializing in different ways to be able to maintain their global presence, and rather than, you know, the old school co-counseling model.
Good point. Emily, did you want to add to that from the funder's perspective?
Sure. I think, you know, from the funder's perspective, you know, a key part of what we consider, and maybe most particularly in highly specialized practices of law like arbitration, you know, the experience of lawyers is a really key underwriting criteria that we consider. And so lawyers that have got, you know, that have come up over time, you know, that have been now through their entire careers practicing, and younger lawyers that are coming up and getting more opportunities, you know, looking back, having more ability to have roles in hearings and significant roles through, you know, because of technology and not having quite as much travel burden. I think that, you know, gives us a much broader broader group of lawyers to work with. And we're very pleased, and I think have found that lawyers that have local connections to their clients and have a true understanding of the culture that they do businesses in. And I guess that brings me to another critical criteria than when Burford thinks about underwriting is the actual commercial context that a dispute arises from. And so having, you know, lawyers or parties or arbitrators that are overseeing a dispute that is just simply way outside of the cultural experience of the advocates and the arbitrators is just not a, you know, that is just not a place that we want to be in, and a place that we think is a great place to invest money. So having that broader group, broader experience of lawyers and local connections leading cases, I think is has been evolving very much particularly since the pandemic. It's, you know, things change slowly, and then more quickly, and continue, you know, hope to see much more rapid change as we continue to go into the future.
Interesting. So I'm gonna throw out what I think is another change that was, I think, happening, but really pushed hard during the pandemic. And so now, all this time later, I want to know what your thoughts are. I think one of the effects we saw of the pandemic was a coming down of the gatekeepers. So we're all in this very prestigious ASIL panel, and that's obviously, you know, one of the best, you know, the best version of a gatekeeper, right? But it was true that, you know, with some of these organizations that were super prominent in international arbitration, you kind of had to have an in with the organizers, which maybe 40 years ago really meant, you know, probably being, you know, an older white man, or being friends with older white men. But it's no longer just because the IBA, ASIL that creates panels. We've seen this explosion literally of groups, great groups that are specialized, and initiatives such as podcasts, coffee breaks, mute off, and ways to connect that are no longer, in a sense, initiated and controlled. by gatekeepers. So I know, Melinda, that you've been involved in REAL, which is one of the ones I have on my mind, because that's just sort of developed. I wouldn't have traced. I didn't realize it corresponded with the George Floyd death, but I would think it probably did now that I'm looking back. But
yeah,
it was
definitely grew out of that, and it absolutely what that kind of what REAL and organizations like that do, and around the same time, but perhaps more pandemic related, was, for example, Mute Off, that was started by some women, Emma Boyevich for one. So what these kinds of really sort of meetups, I think I would call, did what was to sort of say, we're going to take charge of our own destiny in a way. And that sounds very, messianic or something, but I don't mean it that way. It's just sort of saying, we have the ability to do for ourselves and to influence. And if your problem is with gatekeepers and feeling that gatekeepers are keeping you out, then you have to create opportunity. You have to let states know, for example, that you exist, and that there are younger people, there are more diverse groups of people that can be appointed arbitrators. Because at the end of the day, one of the issues with gatekeepers was that if you have your traditional arbitration clause, and not much different if it's a state, investor state case or a commercial case, is you have two arbitrators who get together and decide who is the third. Generally, institutions sometimes participated in that, but not always. It depended on what vehicle there was in front of them. And so the more you have people being exposed to each other and gaining confidence and respect and learning about the experience of other people, then you can influence that process. And that is what we've seen over the years, is you had organizations that allowed people to meet and get to know each other and know about the work that other people had done. And at the end of the day, it's always this way, and giving people a chance, an opportunity to show that what they look like on paper is just as good in reality. And so what I totally agree, these organizations were able to create that confidence and give opportunities. And once someone gets an opportunity, then it sort of usually will snowball from that, because people make the commitment to it.
And the average age of the organizers too, I think, dropped about 20 years during the pandemic too.
More probably.
Sorry, Shannon, you were going to say something?
No, I was just going to echo that point. And I think that it really was, again, back to the great disruptor of the pandemic that prompted all of these changes. And another organization such as the Rising Arbitrators Initiative, these young arbitrators then at that time, now they're prominent, because they had access to information earlier and they sought access to it, and they organized themselves to be able to participate in the dialogue of how to become an arbitrator, when they were ready, when they thought they were ready. And I think that that's something that we have seen more and more of in the last 10 years, because there are the gatekeepers, the gates are low, and technology has allowed for us to connect in a way that, the traditionalists were not used to, and either had to learn or get out of the game. And at the same time, during the pandemic, we saw more of the senior statesmen, and had access to, certainly I participated in this interview series where all these senior practitioners at that time came out and shared with them and shared with the world an hour's worth of their time. And some of it was personal, some of it was professional perspectives. And that was something that you probably didn't have access to, pre-pandemic. And so now when we talk about democratization, technology, and what we are doing here today is something that has, I think, been the real game changer. Yeah, technology has definitely been part of what's broken down the gatekeepers. And
when I think about it, one of the things I can contrast it to is, for example, arbitral women, which I mean, I think they did amazing work, but they had to be persistent for 15 years and basically knocking at the door, asking the power brokers to let them in. Now it just seems they're like, no, we're here. Get used to it. And all these groups are kind of neat to see. And you're right, I think, Tim, that really it's technology that facilitated their existence.
Absolutely.
So, yeah. So, you know, the other really big thing that's going on, and I think it is, you know, very much in many ways a power struggle of sorts, which is, I guess, what part of democratization is too. So starting next week, another session of Working Group 3 in Untitled in Vienna, which I think is actually at least partially in person. What came out of all that Working Group 3 stuff back in 2021? Like what kinds of changes do you think in 2021 they were hoping to be able to realize by 2031?
Well, as you know, the process has had a new phase, let's say so, in 2017. And then because of the consensus of the different states participating in the reform, there has been many achievements by 2022. A permanent court of investment arbitration was established, a 2 tiers court. Also, the different governments agreed on a code of conduct for arbitrators. So there has been a significant reduction of cases questioning the ethics and the independence and impartiality of arbitrators. Also, and I think that this point will be very important for Emily, there was the Convention on Third-Party Funding, which made mandatory the transparency of the agreement or the contract since the beginning of the claim, and specifically since the notification of the arbitration, which for governments was a very important issue. So yes, there has been very many improvements because of G3 multi-laterals reform. And if you ask me to pick up one main achievement, I think that will be the one concerning the predictability and coherence of the different interpretations of on the different investment awards regarding, for example, standards like indirect expropriation, foreign equitable treatment, investment definition. I'll pick that one as my top one.
So I think there's great hope for all of these achievements. It took a long time, as Slater mentioned. It started really back in 2017, 2018, but there's definitely, I think, hope. I participated in a similar exercise to this 15 years ago, or 16 years ago, back in about 2014 for ICSID's 50th anniversary. And I predicted, not quite exactly the case, but I predicted that in the future there would be 10 years out. So let's say it would have been, I guess, 2025, that there would be an appellate type court stationed in New York. Well, I missed my New York court, but nonetheless, we've seen some of this come to fruition. At the time, it was a crazy, or some thought a crazy, wacky idea. It was certainly not desired, but we've seen that some of it in some form has come. So now that the challenge is to see the promise and the reality of all of that meet the expectations. And I think that is on both sides, either that it meet the expectation expectations in the sense that it was necessary. There are many who I think still believe it's not. And so I think the spotlight will be on the organization. And I think from my personal perspective, to avoid the mishaps of the model for that, which is the World Trade Organization, which as we know is no longer around. So I think that's the challenge.
So Emily, you have to, I think, accept the baton, but you're not
Yes.
limited, of course, to third-party funding on your commentary.
Yeah, I think, I mean, addressing Lady Lynn's point on transparency of funding, but also her larger point on more consistency on standards and rulings, and I think bringing more transparency in general, I think will be, is an important evolution, and I really think, what we're starting to see, and I hope we'll continue to see in the future, as important as it is to have eminent and extremely experienced arbitrators overseeing cases from the perspective of, someone who works, almost exclusively with claimants, and the focus on arbitrator selection, where there's more consistency in the rules being applied, there's less there's less need to be so focused on the idiosyncrasies and the past rulings of particular arbitrators. And I really do think that that will help lead to additional breadth of arbitrator selection. And I hope just less emphasis on selecting the same arbitrators because you have a sense of how they're going to rule on a particular issue. And I think in terms of general of transparency, of third-party funding, I think we can agree that it is a important factor to understand. I would disagree that the terms of funding are necessary or relevant to a dispute. But understanding the parties that are involved is an important part of transparency, and certainly on ensuring that arbitrators are not conflicted.
Yeah.
Oh, sorry, go ahead.
Nope, it's all yours.
Oh, I was just going to pass the baton to Jen.
Yeah, no, I think what Emily says is quite interesting, and I think we're certainly seeing now arbitral precedents play a much greater role in how decisions are made across the board, whether it be with the arbitrator or with counsel, choosing institutions, enforcement. I think having more transparency certainly we've seen that in investment arbitration for years, but also in commercial arbitration now. I think processes and procedures will be more streamlined, have become more streamlined, and this facilitates in allowing for a greater pool of arbitrators to be able to conduct themselves in a more harmonized way.
I think that's a really terrific insight about the balance between, or the relationship between arbitrator selection, which is very idiosyncratic, mainly because, we vote international arbitration is very flexible. What the flip side of that is it's very unpredictable. And the way you get predictability is in the arbitrator selection process. And I think that's a nice response to some of the complaints of too many guidelines, too many rules. Well, that's actually a form of democratization. So if you go back 50, 60 years ago, this was like a closed secret society that you had to know the secret handshake to get into. Nobody knew what terms of reference were, what was supposed to be going in them, or what was the best practice. And so the other democratization, which I also think has sort of started flourishing in the pandemic, is scholarship, right? So one of the ways you build a career is you author, minimum blog posts, but books and treatises and articles and book chapters, and you participate in task forces that revise existing guidelines or create new ones or whatever. And the opportunity for more and more people to participate in that, essentially our own internal rulemaking process, is a very fundamental way that I think the regime, the practice area has democratized. When I'm teaching the IBA rules on the taking of evidence, I actually look at the 3 different committees, task force, I forget which one they're called, over the years that have revised them. And I think the first one, I think there might have been one one diverse person on the whole task force. And the next one, you see, they're making an effort, they've got a few more. And then you see the current one, and it's clear our community's figured out that it's an embarrassment as a multicultural, community, we can't do better on diversity. So what do you think about the different sources that have been published to also by some of these groups? I mean, there's overlap, right? There's the pledge. There have been different kind of rules and guidelines drafted outside of, again, the main gatekeeper type of organizations. Any reaction to that?
I can certainly briefly comment on that. I think it's fantastic to have more ideas and put them on the table. Sometimes they work, sometimes they don't. And you see that, time will test these different products out there. And those that remain will flourish. But we've seen the IBA rules for many years now. Institutional rules, as you remember, used to be, amended every 20 years. And then there became a trend where they were revised every 5 years. I mean, what that will look like, going forward past 2031 is something that I think is difficult to predict, but I think that we have to be a little bit mindful of too much change for the sake of change.
Yeah, and if everyone's trying to make their mark by participating in change, it could backfire. Anyone else?
And not only like the different initiatives and task forces, but let's consider, for example, the pandemic, how quick many different institutions were able to regulate, for example, or to promote guidelines for virtual hearings, taking into consideration the main challenges for virtual hearings, for example, technology, to guarantee that, for example, a witness is without any other person that could influence on his participation. How quick the different institutions were able to promote these rules. And I think that is part of the democratization process, and how the different stakeholders were paying attention to what happened and what the different stakeholders were expecting from the different institutions to respond to the demands and to the questions and the concerns that we all had with or have with arbitration.
Hey, I would say to that, totally agree. Part of democratization is economic freedom. And, I certainly remember experiencing, situations where tribunals were very reluctant to not have someone come in person, even to have someone appear on a video screen to give to be present for a 45-minute cross-examination was a huge deal, and required special permission and this and that and the other. And it's amazing, turned in the pandemic where now if you've got sort of a less important witness, you almost never see them live. You see them in their 360-degree room or whatever the mechanics of it, the technological features of it are. But I think certainly that also, I go back to the economic aspect of that, is you don't have to pay to fly someone who is a minor player, let's say, around halfway around the world or 6 hours away to sit around for a week and a half to, waiting for a testimony that is very brief. You multiply that by the number of times you have witnesses like that. That's also, I think, make access on both sides and different kinds of arbitrations, whether it's investor state or commercial. It gives more freedom, and I think that means greater democracy.
I
Okay. Go ahead.
I was just gonna pick up on that point. I mean, as someone who pays for a lot of that travel, it's I couldn't agree more. But I also, having people, and I can't remember who made the point earlier about some of the availability of eminent practitioners to sort of, through technology, offer time to the broader practice. I mean, having those being freed up, not just the economic freedom, but the freedom of people's time to be able to contribute, work on other matters or contribute more broadly, I think is an important democratization as well. That's enabled by just allowing people to be where they are, unless it's absolutely necessary. It allows people to attend hearings they wouldn't be able to attend, clients or government officials. I think it has been an incredibly helpful, in U.S. litigation, where I spend a lot of my time too, as well as arbitration, where there is so much travel halfway around the world, all the way around the world.
Yeah. Okay, we have just over 2 minutes left. And what I'm going to do is I'm going to ask you to go back to your 2021 selves and tell us what would be your greatest wish for international arbitration 10 years from now in 2031. You each have 30 seconds. So starting with Shen, you want to go first?
Sure, I would say true internationalization in international arbitration. Seamless, color nuanced, colorblind arbitration.
Okay, tough one to follow. Lady Lynn, you want to go next?
Yes, very tough question. Can I pick 5? No.
Yeah, just have to go very
No.
quickly through them.
Deeply from my heart, I will insist in jurisprudence constant coherence, predictability, not only from a state, as a selfish state perspective, to know when it is fulfilling its commitments, but also the investor himself to know what to expect from a sovereign.
Excellent point. Melinda, you want to go next?
That's a tough one. I'm going to try to piggyback on what Shan said and basically just say the hope would be that I don't know that we will have true diversity, that there's so many aspects to that. It's, sort of the comfort of feeling that you're as an advocate, that you're doing the best for your client and it's unaffected by anything other than you and your performance. And obviously the facts, which you cannot change, but that would be my hope. I'm not sure that in 2031 we will actually be there, but I think that's the hope and we're working towards it.
Okay, Emily, you get the last word.
Yeah, I'm just again going to piggyback, I think, on both Shen and Lady Lynn's points. True democratization of, and internationalization of the practice, and not even having, the most elite lawyers from around the world passing through the most elite institutions to gain access to being a practitioner in international arbitration, but being able to gain a foothold and represent clients and states in their local jurisdictions without having to have that sort of premier stamp, if you will. And I think, I think having more predictable rules and standards, I think would also, benefit both states and clients and parties, all parties.
Yeah, it sounds like what you're saying, I think, which I tend to believe is the kind of heart of diversity, which is enabling everyone to be their best selves and to choose people based, on the merit of their best selves, not excluding people because of other reasons. Or so let me say that was just a great last lightning round. I should say to the audience, I didn't warn them that I was going to do that, so they really stepped up to the plate on that. I want to thank all our panelists for this extraordinary effort in time travel, as well as to our audience for coming out and listening to our views on this. We hope this is a continuing discussion on through 2031 and beyond. Thank you all.
Thanks.